So what happened on Monday was 6 justices of the Supreme Court said that discrimination based on sexual orientation or gender identity is discrimination because of sex. I think this opinion is going to just have an enormous effect in the lives of LGBT Americans. Certainly anybody who works, anybody who wants to work, because after all, this doesn't just keep you from getting fired because of your sexual orientation or gender identity, but it keeps you from being subjected to worse terms of employment. It keeps you from being not hired. It says employers can't take this into account in their hiring practices. But then it just goes so far beyond that. It goes into housing and federally funded schooling, which basically means schooling. It affects our discrimination that's in healthcare. It also will almost certainly have an effect in constitutional rulings about the status of sexual orientation and gender identity under the Equal Protection Clause of the Constitution. Yeah, we were excited to see when the opinions came out on Monday that our brief was mentioned. Clearly it had been read by the justices and made an impact. As it happens, it was cited in one of the dissents. It was cited in the dissenting opinion by Justice Kavanaugh, who was trying to say why we were wrong. But I joke that if the dissent thinks you're wrong, I guess by definition that must mean you're right. In any case, it's interesting that what Justice Kavanaugh was talking about, the reason that he called our brief to attention was that something we said about Brown v. Board of Education. He wanted to talk about how our understanding of the way courts' understanding of discrimination has historically changed. He wanted to say why he thought that was wrong in Brown v. Board of Education. And it just goes to show how deeply entwined these cases about sex discrimination, sexual orientation discrimination, gender identity discrimination, how entwined they are with the long history of discrimination against race and the law that has sprung up around that. It's all really part of the same fight. And arguments that were made not just in Brown v. Board of Education, but also Loving versus Virginia, the case about interracial marriage, those exact arguments were being made here again in this case. I was surprised that it was Justice Gorsuch. My outside-the-box prediction was that it was going to be Justice Kavanaugh, but doing something very similar. And what that is for somebody who has associated himself with Justice Scalia and Justice Scalia's textualist mode of interpretation, where you just look to the words of the text and you care about what Congress wrote, not what Congress was thinking about. That's an idea deeply associated with Justice Scalia. And so the thought there was that one of these conservative justices might step up and say, I'm the new Scalia. I'm going to follow textualism no matter where it takes me. So even if it takes me to a surprising result, it's the methodology that matters, not the politics, not the result. I thought that that might be Justice Kavanaugh that would do it. In fact, it was Justice Gorsuch joined by Chief Justice Roberts here. So Justice Gorsuch is just saying, you look to the words, not to the minds and expectations of the people that wrote those words.